right. Welcome, everybody. Great to see everyone. Thanks for coming. My name is John Goldberg. I'm the interim dean at Harvard Law School, and I'm delighted to welcome you to the first Rappaport Forum of the year. As many of you know, our Rappaport Forum was launched in 2020 to promote and model full, vigorous, and civil discourse on complex and challenging issues facing our community, our nation, and our world. Funded by the Phyllis and Jerome Lyle Rappaport Foundation, this series honors its namesake, Jerry Rappaport, who, as an HLS 1L back in March 1946, established the original HLS Forum. In the decades that followed, the forum was broadcast live on this thing called radio and featured leaders and luminaries ranging from Eleanor Roosevelt, John F. Kennedy, Martin Luther King Jr., and Fidel Castro, to more contemporary voices, including a more famous Goldberg named Whoopi. I want to thank the Rappaport Foundation for supporting this vital effort, as Jerry Rappaport once put it, to model a process that is core to our democracy, and I might add, to our academic community and to our chosen profession. I also want to recognize and thank James Siegel, a member of the Foundation's board, and Sean Horrigan, Director of Communications, for demonstrating the Foundation's continued support by being with us here today. Thank you. I'm almost done, but my last task is to introduce, and I'm thrilled to introduce, my colleague and friend, Jody Freeman, who will moderate today's discussion. Jody Freeman is the Archibald Cox Professor of Law and among the world's leading scholars of administrative law and environmental law. I can think of nobody more suited to lead today's discussion than she. She has served as a counselor for energy and climate change in the Obama administration, is a member of the American Academy of Arts and Sciences, a fellow of the American College of Environmental Lawyers, and a member of the Council on Foreign Relations. While in the White House, she was the architect of President Obama's historic agreement with the U.S. auto industry to double fuel efficiency standards. She also worked with the Biden transition team on the administration's climate action plan. Professor Freeman has written extensively about climate change, environmental regulation, presidential power, and judicial review, and has been recognized as the second most cited public law scholar in the country. She's also founded Harvard Law School's Environmental and Energy Law program and established the law school's first environmental law clinic. She co-chairs our Presidential Committee on Sustainability at Harvard, and she consults regularly for government and non-governmental parties and speaks at events around the world. Thank you very much, Jody, for doing this. One last thing, please allow me also to welcome our panelists, Professor Gillian Metzger and Ilan Werman, whom Professor Freeman will properly introduce in a moment, but I just wanted to take a moment to thank you both for joining us, and with that, I give you Professor Freeman.
Thank you very much. I couldn't be more delighted to be part of the launch of this year's Rappaport Forum, which is so important and foundational and such a wonderful event for our community. Let me properly introduce our two illustrious guests. Just couldn't be more pleased to have with us first Gillian Metzger, who is the Harlan Fiske Stone Professor of Constitutional Law at Columbia Law School. She is, as many of you know, one of the nation's foremost scholars of administrative law and constitutional law. She's written extensively about issues like the ones we will talk about today, in particular the place of the administrative agencies in our constitutional system, and specifically attacks on the administrative state in some of her leading work. She also is the faculty director of the Constitutional Center? What's the center?
Center for Constitutional Governance.
Center for Constitutional Governance at Columbia. Ilan Werman is also with us, an associate professor at the University of Minnesota, soon to be a full professor at the University of Minnesota. He is also a scholar of administrative law and constitutional law and the 14th Amendment in particular. He has written two books, one on originalism and the other on the 14th Amendment. I can't think of two more relevant, appropriate people to be here today for this debate and discussion. Let me start by just saying the briefest thing about the topic, and that is that Chevron has leapt the fence from the world of kind of technical legal doctrine to the world of common conversation. Barbra Streisand was posting on X about Chevron, you know when that happens that something has gone crazy. The Supreme Court this past term overturned what is known as the Chevron doctrine, the Chevron principle, or Chevron deference. That case was about 40 years old, and it established a presumption about the allocation of authority between courts and agencies over who would fill in the gaps and ambiguities and silences in statutes when Congress did not address them. For 40 years, the presumption was that if Congress didn't address an issue, the legal interpretation, as long as it was reasonable, would fall to the agency tasked with implementing the statute, and courts would presumptively defer. The Supreme Court overturned that doctrine, saying that it conflicted with the Administrative Procedure Act, the kind of Magna Carta statute of administrative law that declares in Section 706 that courts shall decide all relevant questions of law. And the Chevron era abruptly, maybe not so abruptly since we all kind of expected it, came to an end. Now, what does this mean doctrinally? What does this mean in terms of real-world implications for agencies implementing laws in the world? That has been the subject of a vigorous, profound, sometimes quite hyperbolic debate, and that is what we're here to talk about. And so let me pose a first question, just to, before I do that, suggest to you what the format will be. I will pose the initial question. Each of our speakers will have a short time to present their views initially on the topic, and then we'll go into more of a question and answer discussion among the speakers, moderated by me, and toward the end, we'll turn to the audience for questions. So that's our format for today. So to get us started, I think what I will say is, where do you fall on the spectrum of reaction to Chevron? Some have said that it represents the dismantling of the administrative state or the disabling of the administrative state, that it's the end of the world as we know it, hence the musical choice when you were walking in the room. Others have said, no big deal, nothing to see here, Chevron didn't matter in the first place, and if it's overruled, if there are any implications, they're all salutary. There are real polls on this debate, and then there are places to be in the middle. And the question for you is, where do you stand on this question, and how should we be right now?
Well, thanks so much for having me here today. It was suggested that I should go first because the audience is more likely to disagree with me. So I shall attempt to be as disagreeable as possible, but not too disagreeable, because as someone once told me, it's never too late to mess up a full professor vote. So I'll try not to be too disagreeable. But one of my themes in my strict 7 minutes that I've been given is my astonishment that there isn't more agreement on the fundamental issues that we are here to discuss. In my view, some of the Supreme Court's recent and controversial administrative law decisions were not only correct, but should have been 9-0. Let me explain, focusing on the court's approach to interpreting administrative statutes. I'll start with the Loper-Bright case overturning Chevron deference. My claim is that very little separates the best reading of the majority's opinion from the best reading of Justice Kagan's dissent, at least if that dissent is interpreted in light of Kagan's prior opinion in Kaiser. Kagan describes Chevron step 1 as follows. The inquiry at that interpretive step, she wrote, is rigorous. A court must exhaust all the traditional tools of statutory construction to divine statutory meaning. But she says sometimes after all those tools are deployed, the statute remains ambiguous. Now, I think it's important to understand what Justice Kagan means by ambiguity. She told us in Kaiser. First and foremost, a court should not afford deference unless the regulation is genuinely ambiguous. The core theory of deference is that sometimes the law runs out and policy-laden choice is what is left over. So the bottom line, Chevron step 1 should be rigorous, but sometimes the law just runs out. Let me now say 2 things about all this. First, Kagan's description of Chevron would be unrecognizable to most practitioners in the circuit courts. Take the DC Circuit's decision in the Loper-Bright case itself, which I think is representative. The majority concluded that the statute was not wholly unambiguous. There was still some question as to the statute's meaning. Is that a rigorous inquiry? Second, if the courts genuinely deployed a rigorous step 1, then I'm not sure the majority would disagree with anything else Justice Kagan wrote. She explained that sometimes the law just runs out. But if the law has run out, then what are we interpreting? Justice Kagan is quite right that all that would be left over is policymaking, gap filling. That is what the majority opinion also recognizes. The majority, channeling Professor Henry Monahan, writes that sometimes the best reading of a statute is that it delegates policy-making discretion to the agency. So it seems to me that the dissent is saying courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to the agency. And it seems to me that the majority is saying courts should rigorously construe statutes, but sometimes the law runs out, leaving policy-making discretion to agency. Yes, I repeat myself. How is this not a 9-0 decision? Let me now say something about the major questions doctrine, which is the other statutory interpretation development. I will be brief here because I've made my views pretty well known on this. In my paper, Importance and Interpretive Questions in the Virginia Law Review, I've argued that the major questions doctrine is really best understood as a linguistic canon. Now, Justice Barrett adopted a version of this argument in her Biden v. Nebraska concurrence, although I think she went a little beyond what I had suggested in my paper. But naturally, of course, I would think this. I think her concurrence should also have been 9-0. Let me begin here by suggesting that the linguistic account accurately reflects most of the court's major questions cases, despite some of the justices' rhetoric, I admit, which is annoying. Okay, but put that aside. Sticking with West Virginia v. EPA, for example, the court said we are sometimes reluctant to read into ambiguous statutory text an extraordinary delegation claimed to be lurking there. And the word system in that case was at least ambiguous. It could mean a system within a plant, which I think was the most natural meaning and how it had traditionally been interpreted, or it could mean the national energy system. The point is, this was no substantive canon, at least it did not have to be. It was a tool for resolving linguistic ambiguities. So if the doctrine indeed requires a threshold of ambiguity and is about resolving those ambiguities, let me just suggest that I think that's perfectly fine and consistent with textualism. If textualists resolve ambiguities by trying to ascertain which of multiple possible meanings the legislature likely intended, then I think the major questions doctrine accurately accounts for the legislative process. Now, it's true that Congress often likes to delegate tough policy questions to agencies. Okay, that's public choice theory 101. And it's also true that legislators often use deliberate and strategic ambiguity. I suppose that would be public choice theory 201. But the question is whether legislators are likely to delegate the resolution of tough questions through ambiguities, through oblique language. That's the question, and as far as I know, there's only been one empirical study bearing on that question. In that study, Professors Abby Gluck and Lisa Bressman find that congressional legislators and drafters do not typically intend to delegate major authorities, major policy questions through ambiguous language. Now, suppose textualists instead resolve ambiguities by trying to ascertain which of multiple possible meanings an ordinary reader would understand. Well, ordinarily, the recipient of a delegation or of information who is sensitive to the stakes at issue is likely to demand more clarity the higher the stakes. One of your own professors here, Ryan Dorfler, has written about this, and I took most of my inspiration from him. Now, to be sure, that raises the question of what is the high stakes outcome, invalidating the agency action or the agency action itself. Fair enough. But I submit that the question the judge must answer is the meaning of the statute. At least that's the question I'm interested in. And so the likely consequences of the delegation are what must be considered. Now, there's also historical support for this common sense intuition. In early debates over the necessary and proper clause, there was a question whether incorporating a national bank was too great and important a power to be left to implication. Everyone agreed that some authorities, like the power to tax or to declare war, were too important to be left to implication. Madison summarized the point as follows. In admitting or rejecting a constructive authority, not only the degree of its incidentality to an express authority is to be regarded, but the degree of its importance also, since on this will depend the probability or improbability of its being left to construction. This intuition persists in agency law. Here's the third restatement. A reasonable agent should consider whether the principal intended to authorize the commission of collateral acts fraught with major legal implications for the principal. Some things, in other words, just matter too much to be left to guesswork. It's the exact same intuition that we find in the major questions doctrine. Okay, I haven't talked about any of the constitutional decisions, which we're saving for the discussion, so let me just summarize my ultimate conclusion, at least regarding the court's approach to interpreting administrative statutes. Not only do I feel fine about the court's administrative law decisions, I feel quite well. And the question is, why doesn't everyone? Thank you.
Thank you, Ilan. And you brought in the context of West Virginia case that obviously, as you now know, is about the major questions doctrine. Of course, Jillian may feel free to address that as well, but we'll return to it if not, if you want to just stick to Loper-Bright. Jillian, how are you feeling?
I am not so fine, but I also don't think the administrative state is ending. I do think, however, it is becoming increasingly and unjustifiably hamstrung. And I think that courts are claiming greater and greater authority over administrative decision-making and adopting implausibly narrow views of agency power, and in the process overturning core administrative law doctrines and practices on which agencies and Congress had long relied. So I'm not doing that well at the moment. Before I do more of a detailed discussion of Loper-Bright or West Virginia, I do want to just start by taking a step back and giving a couple of bigger picture comments. And part of that is because these recent decisions don't come out of the blue. As Jody mentioned, I've done some work on the attacks on the administrative state at the Supreme Court. And they go back to 2010. They've intensified in recent years when the court has gotten its conservative supermajority starting in the fall of 2020. And this judicial pullback and attack is part of a broader sort of anti-administrative turn in the country with greater political divides over administrative government. So go 2010-ish, Tea Party, you have calls to deconstruct the administrative state. Now we have Project 2025. This is all very relevant backdrop in thinking about these decisions. And I think so for a couple of reasons. One is because these decisions are not politically and ideologically neutral. They can't just be viewed as through a doctrinal lens. They reflect, I think, a deep conservative anxiety about administrative power. And I think that anxiety is quite genuine. I think there is a sense that our administrative government is no longer in keeping with its constitutional framework, and that agencies are seizing power and aggrandizing themselves. But nonetheless, that is, I think, what is motivating and underlies many of these decisions. I think that understanding that backdrop highlights that part of what we need to assess is whether or not it's appropriate for the courts to be doing this pullback, or whether or not this is a deeply political issue that should perhaps be left to the political branches. I also think that this backdrop is important to understanding the impact of decisions like Loper-Bright, because you really have to think about the cumulative impact of everything the court is doing and everything that is happening in the political sphere on the executive branch, right? So just thinking of last term, it's not just Loper-Bright, it's also SEC versus Jarkisy, which dramatically made dramatic pullbacks on administrative adjudication.
Can you give us one sentence on Jarkisy, because they don't all know?
Yes. So Jarkisy is a case that involved whether or not you could bring a civil penalty for a security fraud violation before agency adjudicators, or that claim had to be brought in federal court because of the Seventh Amendment, because of Article 3. And maybe when we talk about it, I'm happy to give more on it. Another decision, Corner Post, is also relevant. I'm sure we'll be talking about Corner Post, but for now, the bottom line of Corner Post is that a whole bunch of agency past decisions and rules and interpretations and actions are now open to challenge that people thought were well settled. So all of that is what agencies are dealing with when they're looking at this case. And I also think that it's important to realize that we are not just talking about the Supreme Court. We are talking also about circuit courts and district courts, a lot of whom are even more opposed to administrative power and adjudicating in cases that are sort of obviously political, brought by red states or blue states, for example. Okay. So with that background, let me just say a few things on Loper-Bright. So, I think that Ilan's framing of this is why isn't everybody happy, and there's not much difference, is an interesting one. I do think that there was variation in how lower courts addressed Chevron deference, for sure. There was, some had more rigorous step ones, others had less so. I think that actually courts have been moving towards, in general, more rigorous and picking up their signals from cases like Kaiser. The key thing about Loper-Bright, it does leave room for administrative interpretations to still govern. There's language we can parse.
Footnotes 5 and 6.
Yeah, exactly. It's also interesting, by the way, courts have started to uphold agencies more on their textual analyses, and agencies are putting more effort into their textual analyses. So there are a lot of ways in which you may think and conclude that agency interpretations may still continue to sometimes win. But we have to understand that Loper-Bright introduces tremendous uncertainty and transaction costs, and we have to figure out what this new rubric means, what kinds of delegations will the court find exist, what language will signal an instance when the agency's interpretation can survive, how will the major questions doctrine fit in, how broadly will we read prior Chevron decisions, and so on, right? So tremendous uncertainty at a minimum versus, as Kaiser did, working within the confines of the Chevron framework and trying to tighten it. And again, all of these questions are going to be coming up through the lower courts and be brought in forums, through forum shopping, in courts that are hostile to administrative power. It's not, however, just a transitional cost. I also think that what you see in Loper-Bright is a particular view about law and a particular view about interpretation. That means that agencies are going to end up with more constrained authority and much less flexibility to deal with new circumstances and needs. To begin with, this is just an empirical point, agencies are going to be way more cautious. It is not worth putting in the time to develop an interpretation that is just going to be reversed in a couple of years for the courts. All right, so there's a natural tendency there to pull back. I also think that pulling back on agency authority is a good part of the purpose of Loper-Bright, and courts and agencies can see that too. But in addition, Loper-Bright is premised on the idea that there is a single best interpretation. It is a rejection of legal realism. It is rejection of the idea that the line between policymaking and law is not clear, that law could be indeterminate. And it is also a rejection of the idea that there could be good reasons for policy and good reasons for interpretations changing over time in response to changed policy views, changed circumstances, changed needs. All of that is what lay at the core of Chevron in terms of the allocation of power, and that is what the court is fundamentally rejecting here. I also think that the court's rationale, which was based on as you mentioned, on the Administrative Procedure Act, requiring independent judgment, was particularly weak. I think that the Monahan piece that was referenced answers the question, because when courts are doing that initial investigation of the independent meaning of a statute, they are doing the independent judgment that is required. We do not, once they determine that there is something that is being delegated, at that point, there is no more Article 3 reason why they have to be doing independent judgment. They've already done it. So I think the rationale is very weak. I also think we're going to end up with the same kinds of inconsistencies we have now, and so it will be costs for nothing, so I don't feel so good.
She really rushed you, so I don't feel so good, because I was gesturing time is up. I want to read you one thing, which is the excerpt from the opinion from the Chief Justice's majority opinion in Loper-Bright, which you both alluded to, and that is a couple of sentences where the court says, in a case involving an agency, of course the statute's meaning may well be that the agency is authorized to exercise a degree of discretion. Congress has often enacted such statutes. For example, some statutes expressly delegate to an agency authority to give meaning to particular statutory terms. Others empower an agency to prescribe rules to fill up the details of a statutory scheme or to regulate subject to the limits imposed by a term or phrase that leaves agencies with flexibility. Footnotes 5 and 6, which provide a few examples, including some examples that say things like in the judgment of the administrator or as necessary and appropriate, which leads to the following question. I'm impersonating Adrian Vermeule as I say this. Well, what's the big deal? We've gotten rid of Chevron's so-called deference and this artificial sort of two-part test, but it's replaced with what, I'm Adrian, you might call Loper-Bright delegation, which is just let's look for the delegation, spot it, and then decide, as long as the agency uses reasoning, is reasonable, we'll defer. What's the big difference? We've traded one for the other. Everybody take a breath. Elon? I feel like you're going to say yes.
Yeah, QED.
Yeah,
And
okay.
that's more or less my point. And so I guess what I'll do is I'll sharpen it in the following way and then see perhaps if Jillian has a reaction to it, which is, because it gets to the legal realist point, that it's true, and Cass Sunstein has written a lot about this as well, following the legal realists in the 1920s and 30s. Part of the motivating principle here behind deference to agency interpretations is this idea that all interpretation inherently entails policymaking, that there's no difference between interpretation and policymaking. Now suppose for a moment that's wrong, and I have some examples, by the way, where I would like to add, where Chevron deference was afforded, and I'd like to ask if the legal realist really insists that that's a policy question or you're just misreading words. Okay, I have some examples, and I think that goes to the political valence as well. But suppose for a moment that that's not true. Okay, suppose that there are going to be borderline cases where the two plausible interpretations are totally equally plausible. Then I admit that's a policy choice at that point. But more often than not, the statute just says something like, just and reasonable, fair and equitable. I know what fair means. I know what equitable means. I know what reasonable means. It's not a question of meaning. It's a question of policy judgment. That is, I think, what they are referring to in those footnotes and in the body of the text. So suppose for a moment that there's actually a difference between ambiguities, which is simply uncertainty in the actual meaning of the words, and the policymaking, gap-filling, legislative discretion that the words properly interpreted leave the agency. If that's true, I think what the majority is saying is no deference on the first kind, but of course deference on the second kind. It wouldn't even be called deference because you're not interpreting law at that point. You're just making policy. It's legislative gap filling, the promulgation of legislative rules pursuant to a rulemaking authority. And what the courts do there is arbitrary and capricious review, right? As I think it was Kavanaugh said in the Kaiser concurrence, that's more the stuff of State Farm, right, than Chevron and Auer. So supposing that's true, again, this is important because
We don't all know State Farm yet, so for those of you who don't, State Farm is deference to agency policy decisions that based on sort of a demonstration of reasonableness, support in the record, rational person, not missing any gaps in the reasoning sort of thing.
Right, so, so what I will say is the majority opinion routinely says ambiguities and gaps, two different things. Resolving interpretive ambiguities and filling in legislative details. It's not a matter of interpreting words. Sometimes the statute just says, okay, survey this, survey land using the nearest trees or whatever. Okay, well, there are no trees nearby. Can I use this marker? That's not an interpretive question. That's a question of whether Congress has delegated policymaking discretion to fill that gap, fill those details if there aren't any trees. I'm not interpreting the word trees, right, in that statute. And Justice Kagan's opinion never distinguishes the two. She treats ambiguities as both of these things. But I think the majority says these are two different things and specifically says legislative gap filling is okay. Leaving details is okay.
Okay, Jillian.
I agree. They say the legislative gap filling is okay. I think the question is going to be what do they consider legislative gap filling versus not? And that's where we get into uncertainty and transition costs and a whole lot of effort. I also think that, so let me put my cards on the table. I don't think there is any kind of clear difference between ambiguities and gap filling. I don't think there is. There are certainly some examples where there could be. I also don't think that every interpretive question is a question of policy. I think the point is there's a range in the middle. And how do you want to approach the range in the middle? And what really strikes me as you were talking, Ilan, is how different the perspective is somebody who is trying to regulate, develop a policy, versus how the issue then gets presented. Is it ambiguity versus gap filling? Nobody at the EPA, I think, is thinking, is it an ambiguity or is it a gap filling?
Now they are.
Now they are. Now they are. And this leads to more dominance of lawyers and legal speaking, which is not going to lead necessarily to the most intelligent, intelligible, effective regulatory scheme.
But good for your careers. Okay,
I hate to tell you guys this, but that's not my top priority. So that I think is a very real concern that we have to think about. And part of the reason why Kagan doesn't divide those lines is because this is her point. Her point is that the reason why Congress is giving this program to an agency to implement is in part because the agency has the expertise and the experience to figure out how to do whatever of those two things you end up in. And there are some things that an agency is going to try and do that Kagan would say, yeah, that's beyond the pale, sorry. And then there are things that she thinks would be clear, but there's a lot in that middle gap. And trying to draw a line between ambiguity and gap filling isn't an intelligent way, in my view, to try and go about figuring out the best scheme of regulation.
Let me just give you a list. Examples are always so useful because these administrative law discussions become so abstract and they're ultimately about allocation of authority between courts and agencies at the highest level. But in the on-the-ground sense, agencies have to do work and they have to decide what statutes mean in order to accomplish what they see as their missions, and they encounter language and they have to figure out the language. And so I just want to read some examples. The list comes from conversations with colleagues like my colleague here, Andy Mergen, and my great colleague, Richard Lazarus, and Matthew Stevenson. And here's some words, okay? Uh-oh. Yeah, these are words. What if a statute directs the agency to adopt regulations that are necessary to achieve some end, or that to determine what poses a substantial or a significant risk, or tells an agency to prohibit unfair or inequitable or discriminatory practices, or to decide what's large or dangerous, or to do something promptly, or decide what's similar or feasible or probable. And is that an ambiguity? Is it gap filling? Is it something the court must decide? Is it something that's a policymaking exercise? What we're really talking about is thousands of decisions like this. If you I flipped open my environmental law statute book one day just for the fun of it, and I found scores of these interpretive questions that I struggle to determine whether they're policymaking or whether there's some mix of law and fact, and it's just as complicated as trying to find ambiguity at step one of Chevron. Can you help me with this, help explain to our folks, how do you think about that in light of the doctrinal decision?
So let me answer the question that I wish was posed, which would be beneficial to me, and then I will answer this one, which is harder.
This is the best of media training.
Okay,
Never answer the question. Go.
Except usually they just don't answer the question. I'm going to confess that I'm going to dodge, and then I'm going to back it up. Let me give you examples where Chevron deference was deployed. And then I'll address this necessary, reasonable, which I think I've already addressed a little bit. And then I do this for a couple purposes. Number one, is there really conservative valence here? And number two is, I would just love to know what the legal realists think, right? And maybe the answer is what Jillian says, is actually, no, there's obviously some difference between interpretation and policy, and maybe the fight is just how big is that difference. But okay, then we're fighting about a matter of degree, and then I still feel okay, and I would think others should as well. But here's two cases I hate. Barnard v. Walton, okay, involved the Social Security Act, and it authorizes disability benefits, okay, to anybody whose inability to engage in any substantial gainful activity by reason of a medically determinable impairment which has lasted or can be expected to last for a continuous period of not less than 12 months. What does this mean? It means if you can't work for 11 months, you get paid disability for that 11 months if your disability was expected to last for 12 months or more. That individual was denied disability benefits for the 11 months of work. Why? Because the agency said, well, which can be expected to last for 12 months or more could be interpreted to modify the inability to work as opposed to the impairment. No, it can't. Like, no reasonable person looking at that statute, okay, can interpret it that way. You just can't do it. Now, maybe the agency has a rulemaking authority that allows it to impose additional requirements, like an inability to work, and that would be a question of interpreting the rulemaking authority. But that's not a concern, unless liberals don't want to give Social Security benefits now, let me give you another example. The Board of Immigration Appeals, or I guess whatever the agency is now, it's changed so many times.
It's still the BIA.
It's still the BIA. They deported an immigrant who was here for being convicted of a crime of child abuse or neglect. But actually, the crime of which he'd been committed was child endangerment in California for driving under the influence of alcohol with the child in the front seat not wearing a seatbelt. That's endangerment, I grant. Is that abusing the child? Not in any ordinary sense of the word abuse. Is that abandoning the child? No, he's right there. Is that neglecting the child? You could stretch it, which is what they did. They said, you know what, close enough for government work, deport him. What would the legal realists say about that? Is that a question of policy? Or are you just misinterpreting the words? Is that liberal? Is that conservative? Right? So if the effect of the Loper-Bright decision is to say, no more of that nonsense, but we can fight in the middle, over exactly whether necessary and appropriate, is there more interpretation to do in that statute, then I'm still sleeping well, guys.
Jillian, you can avoid my question too.
No, I'm going to avoid the examples.
Okay.
We can come up with any number of really stupid agency moves if you want. I have my own supply. I don't think that's what the battle is about and what's sparking the concerns. I think the concerns are really more one step up. It's a meta concern about where the power is going to be. Is it going to be with courts or is it going to be with agencies? In addition, what does that do to Congress, who ultimately both sides, liberal and conservative, are concerned about preserving the power of? But one of the things that you don't see in the Loper-Bright opinion is a sense of what the impact might be on a Congress that for 40 years has been delegating authority against the backdrop of Chevron, and what they might think of how their words might be interpreted. Granted, it is one of the few interpretive doctrines that they appear to be quite aware of, how they might be expecting their words to be interpreted in the process. They may be delegating authority to agencies who then use it in some decisions that are not reasoned decision-making. That's one other way you can get at that. But it's Congress allocating that power to agencies. And on the whole, at the level at which we should be assessing this, I would far rather have the EPA or choose your agency making determinations about how to apply terms, even if they occasionally get it wrong, in my view, than to be having independent courts who really don't have experience with those regimes, don't understand the underlying issues, don't have the relevant technological expertise in many instances to do so.
Can I take us then to that level? Let's talk, we talk about doctrinal law, of course, we're law professors, law students, and consumers of legal doctrine, but let's talk about on the ground how this plays out in the lower courts. So will there be more litigation? Will there be chaos? Will there be uncertainty? Will there be churn? Will it burden DOJ a lot, a little bit, because DOJ is going to have to be in the federal courts litigating the interpretation of lots and lots of statutory provisions? How do you see this playing out? Well, you suggested it will chill agency rulemaking, it will make them more cautious, more time-consuming. How will this affect the administrative state, in quotation marks, and in particular DOJ that has to go in the federal courts and fight about the meaning of these statutory terms? I'll start with you this time, Jillian.
Sure. So one thing is, I don't think we're going to see it, but I think they need a bigger budget because, yeah, it's going to take a lot of resources to go in and, we are already seeing Loper Bright being raised across the country. We are seeing the major questions doctrine being raised across the country. We are seeing courts taking different approaches to this. I did a very quick back-of-the-envelope survey of the Fifth Circuit in the last 3 months, June through August of 2024. I am not making any statements about the accuracy of these numbers, but on my count, in that 3-month period, they've in 27 cases involving a challenge to a regulatory action as being unsupported by statutory authority, they granted a PI or a stay in 22 of them in the district courts or the Fifth Circuit itself.
Were those all in Amarillo, though, Texas?
They weren't all Amarillo.
Oh, okay.
There were some in Amarillo.
But there is forum shopping going on.
There is serious forum shopping going on. So huge resources to defend. What is also going to happen is you're going to get these initial stays. You're going to get these programs that are then halted. And that just stops a regulatory development. You can't have a sensible process. Even if you think you're absolutely in the right, you have to take into account if you are a reasonable administrator and you have a goal you want to take, you could take this step that you know is going to immediately get challenged. Maybe this other step will be more likely to be sustained. There are very strong reasons to take the second step, even if you think the first one might be the better and effective means. So I think we're going to be seeing that. I think we're going to see just a lot of cautiousness, a lot of discussion, a lot of sort of not knowing whether to move, legal costs. This is just, there's going to be churn.
Elon?
So I want to say two things and kind of take it in reverse order. I do think the injunctions are a problem. And there was a Rappaport forum 2 years ago, 3 years ago on this? Some number of terms ago on the issue of nationwide injunctions. Now, some people say they're supported by universal vacatur of a rule is supported by the text of the APA. People are fighting about this. Whether that's true or not, I mean, it is problematic. And I do think if we narrowed relief to the parties to a case, that would mitigate a lot of the problems of this process. This is not supposed to be about that discussion, but I don't think it's unimportant. To be clear, when we say an injunction that isn't nationwide or universal, it doesn't mean it isn't nationwide as to the plaintiffs in that case. It is. It means wherever the plaintiff is, the agency can't do X, Y, or Z to that plaintiff. But whether it could do X, Y, or Z to 300 million other Americans, they'll have to litigate when it comes, to their turn, or until the Supreme Court resolves it. So that's a separate question, I think, and it is a problem. And I will say that I think the formalists, originalists, conservatives have been fighting against this, largely when it was, of course, the liberal judges enjoining the Trump administration. And now that, like everything else in Washington, there's been a 180 U-turn. And when it's the Trump judges enjoining the Biden administration policies, everyone starts to realize, oh, hey, yeah, maybe this is a problem. But I think that's a separate question. On everything else, in terms of the actual merits of the interpretation, let me just throw one other thing here, and I hope this is somewhat responsive. There is a canon of interpretation that would still apply, And there's this, they come in a pair. It's the canon that says an agency's contemporaneous interpretation of a statute, and if that interpretation is longstanding, is good evidence of what the statute means. In other words, if the statute was enacted 80 years ago or 100 years ago, and after it was enacted, immediately after, the agency tasked with administering that statute had to decide, okay, we have to decide what this means in order to implement the statute. If they chose some interpretation of that statute, and that has been longstanding, that is good evidence, right? 80 years later, I'm a court, I don't know exactly why they enacted it, I wasn't there. That is evidence of what the law is. It isn't dispositive, you aren't deferring to it. It's an input into the interpretive process. But Chevron said exactly the opposite, that they can switch on a dime. And if we go back to the longstanding and contemporaneous, again, I'll sleep fine.
Was the leaning forward, Jillian, a rebuttal? Would you, yeah.
Yeah, it was. So just a couple things. One thing, I just think it's important to note, you can tailor, this is just a very discrete point, you can tailor a preliminary injunction to address one person. For the Department of Judgment and the government, they're not going to be, it's going to apply more broadly. You just have to recognize that's how they have to proceed. I wanted to talk about this contemporaneous because it gets us into what I think of as actually one of the biggest problems with Loper-Bright. And it is this idea that law has a single meaning. Maybe it's contemporaneous, right? And that it's suspect if it changes over time. Well, that reflects, again, the idea that there is something called law, and there is something called policy. Never the twain should meet. We can distinguish between the two, and the only thing that can change is policy. And that when Congress delegates very broadly, Congress has a very clear meaning in mind, and that it didn't delegate broadly in order for the agency, perhaps, to change to address new circumstances, new needs. Part of the purpose of agency and administrative government is precisely to allow the experience and expertise developed over time to then address new problems. That is why we have statutes that delegate broadly. That is also why it is that sometimes there will be ambiguities, because the Congress who is enacting a statute doesn't have in mind the problem that's going to come up in 30 years. Maybe, some of them they do, but a lot of them they don't. So you're necessarily going to face ambiguities as you apply that law to new circumstances. And what I find, sort of fundamentally troubling is this idea that because we interpreted it that way in the past, that's the only thing that statute can mean. And we can't have that meaning adapt to face our new needs over time, even although the text of the statute could be read that way.
So picking up on this, there's a theme of kind of overturning Chevron. It might be an anti-change kind of move. It might be an anti-aggressive or creative regulatory action kind of move. But I've always wondered why both sides of the political aisle aren't fans of Chevron, because it's supposed to be neutral, right? The idea of deferring to the agencies to fill in gaps and ambiguities and silences and statutes, well, that benefits whoever owns the government, right? So if you've got a Republican presidency, they get to fill in the gaps when they're there. And if you've got a Democrat in the White House, they get to fill in the gaps. And you get the room to maneuver within the laws that Congress passed is one of the benefits of winning the election. And why shouldn't everybody say, yay, I won, I get to interpret things to accomplish my policy prerogatives, where there's play in the joints, where there's not, I'm stuck with it. But I'm trying to understand why in recent years, Chevron has become a symbol of administrative overreach, and it has fallen into the political sort of divide in the way that it has, so that conservatives have this antipathy toward this notion of Chevron deference, and liberals or progressives, whatever you want to call them, are fans of it, when Chevron itself was a deregulatory decision in which the progressive side lost and a victory for the conservative challengers. It's fascinating how that changed over time. Can you comment on that, Elon, first, and then Jillian?
So this will be, I guess, a comment from the internal perspective, as someone who considers myself a formalist and originalist and sometimes a conservative. I can, I think, explain what happened. I mean, it is surprising, right? It was the Reagan administration who was asking for deference to its interpretation of the environmental statutes against what was perceived to be an activist progressive DC circuit, okay, in the 1980s. So you can understand in the 1980s why the conservative legal movement wanted more deference, because the courts were stymieing the conservative agendas in the administration on the basis of what conservatives believed to be illegitimate interpretations of the statutes. Right? That's what the Judicial Act. You have to accept these premises. Okay, maybe the premises are wrong. Okay, what's happened in the last 40 years? Well, was it Justice Kagan illustrious former dean of this law school that said we're all originalists now. We're all
Textualists.
textualists
She did
now.
not say
She said
original.
both. She did say both. But then it turns out what she meant by originalism might not be the same thing, right, as what everyone else says by originalism. So she said both, right, including we're all textualists now, which is not inaccurate, right? I mean, the text and the structure, history has much more pride of place now than it did before. So from the conservative perspective, the judiciary is not this freewheeling activist judiciary. And then what has replaced judicial activism or judicial adventurism is executive adventurism. Every 4 years, the White House changes hands, and they look at these statutes and they say, what kind of water can I wrest from this stone? How can I make this as favorable to my administration's policy as possible, even if it's, quite frankly, quite implausible. And it's not always political in that sense. I mean, I think the examples I showed you with the immigration and disability, I don't know which administration did what in that case, but that's where, the conservatives took off. So there's a very cynical story to be told, which is they weren't in power in the courts, now they are in power in the courts. So that's more stable. That's the cynical story, right? The less cynical story is we've solved the problem that we were confronting, and it turns out the original solution to it has led to its own problems. So now that the original problem is solved, let's get rid of that original solution, which has its own problems.
Jillian?
Well, I'm glad you identified the cynical account, so I don't.
I knew you would, so.
I appreciate that move. I do. This is why I think it's important to bump back and to put these particular decisions in the context, because it is part of a political moment. It is part of a very significant debates about the role of administrative government and the kinds of power that government should have. And part of what Chevron is about allowing agencies to adjust and allowing agencies to have expertise and sort of accepting the political accountability of the president as one of the better checks than the independent courts. And that works if you have faith in administrative government on some level. And if you are deeply suspicious and skeptical about administrative government, that is just an avenue towards power grabbing by agencies. Or, as you put it, water wrest from this stone, right? So I think that difference in attitude is fundamental to what is going on here. And when do you start seeing the attacks on Chevron happening? Well, they really kind of do tie in to the post-Tea Party and Obama administration's second term real embrace and push on very, some would say, aggressive administrative actions. One of the things we have to add to the equation is that reaction by the executive branch and by presidents is in part because of stalemates in Congress and because of deep political polarization and divides in this country. Now, I'm not saying that to say it makes it legitimate. We can't get policy through Congress, so let's do it through the executive branch. But I think a political reality is that when there are new problems that have to be addressed and there are pressing policy issues that need to be resolved, and you cannot make a progress on them through the political branch of the legislature, that need to address those issues is going to filter through somewhere else. And part of the concern that I have is that what we are doing with Chevron and Loper and getting rid of it in Loper Bright is that we are removing one of the avenues that we had to try and deal with some of that play in the joints. You still couldn't do an interpretation that was at odds with the plain meaning of the statute, but you could adjust the statutory schemes in ways that addressed new problems as they came up, which meant that you weren't then ham-tied when you have a Congress that isn't able to enact legislation.
So I'm just going to say one last thing, pose one last question to you, and then turn to the audience. And it picks up on both of you alluding to there's a larger context, and in particular, Jillian, you're citing other cases like Jarkazi, and you mentioned, of course, West Virginia. So just for the audience, to make sure we're all on the same page, West Virginia a couple of terms ago announced the major questions doctrine, and the court formally embraced it, saying for certain questions of significant, economic and political significance are just too big a deal. We expect Congress to speak clearly to authorize the agency to act. We now have Loper Bright, which we've been discussing, that rejects the presumption of deference to agencies to fill in the gaps and ambiguities. That was decided, I think, a day after Jarkazi, which said that administrative procedures, in-house proceedings to impose civil fines on violators of statutes for things like fraud actually have to go to a jury trial. And then there was Corner Post, decided also this term, that said the normal 6-year statute of limitations on suing agencies to challenge their rules and other decisions no longer applies, and your cause of action accrues when you are injured, so new plaintiffs can come along and challenge 20-year-old longstanding rules. And I say all this really quickly just to say, this is the larger context in which Chevron is overturned and Loper Bright, and to me, I have a set of views about that larger context and what this means for agencies, and it tends to boil down to, at every turn, agencies get hampered, both in their interpretation, their implementation, and their enforcement. Am I right or wrong? Am I hysterical? Am I overreacting? And am I sounding very hyperbolic and thinking, wow, this is not easy at any turn for agencies trying to figure out how to do the missions that they were assigned? Elon and then Jillian.
There's obviously something in the water, right? In
Here at
DC
HLS?
No.
Yeah.
Maybe it's fluoride, maybe it's something else, I don't know. But there's obviously some movement going on. I don't deny that, but I will just conclude, I guess, I know we're gonna open it up to questions, but conclude this phase by emphasizing that whether the sky is falling, I think, really depends on how you interpret the decisions. Because I don't think that the decisions, if they're each interpreted as broadly as some people claim, then yeah, it starts to look pretty bad for the administrative state. But again, I don't interpret Loper Bright that way. The major questions cases are harder, but I agree with Justice Barrett's sort of approach. I haven't defended jarcossy yet, so let me assume my role here and do that now. Which is to say that 90% of administrative adjudications are totally untouched by jarcossy, which again involved sort of what the court described as a private rights case where somebody was being banned from the securities industry and imposed a $300,000 fine, very much like the Lucia case from a couple years ago. Okay, most agency adjudications deal with public benefits, veterans benefits, Social Security benefits. Those are public rights. Everyone accepts that those are public rights. You don't have to worry about what that is right now. We don't even truly understand what those are. I think I know, but okay, whatever. So those are okay. So it's a small sliver of cases where you have like 5 SEC adjudicators, 5 Federal Trade Commission adjudicators, where yeah, they go after you. The government, the prosecutor, the executive branch is going after you and wants to prohibit you from pursuing your occupation. Yes, most of these are probably fraudsters, like the Lucia case. That scheme was buckets full of money. Like obviously that was a fraud, okay? But the point is, in our system, if they're gonna say you can't engage in your occupation for the rest of your life and you're fined $500,000, $300,000, usually that's the kind of thing we'd expect a court or jury to do. So, in that small sliver of cases, sending them to the juries or to Article III courts, again, like, I feel fine.
Jillian?
Okay, so several things. First of all, you switched from channeling your inner Adrian Vermeule there with that question.
No, I did. I moved from Adrian,
Just a little bit. On your question, I don't think you're being hysterical. I think we have to see how things play out. Mm-hmm. What I would say is I think we're in the process of seeing a new constitutional construction happening. We had the New Deal settlement, we had certain views of agencies and certain views of government, and what we have been getting over the last 10 to 20, 15 years now of the Roberts Court is forcing us into a different phase, and I don't think we fully know what that's going to be. I do think it's very interesting that Roberts did not decide the Loper Bright case on the constitutional grounds, and that suggests
or the MQD.
Yeah, they may have legislative delegation next term. Who knows if they take a case out of the FCC that presents that. So I think we're still open. I'm actually impressed, Ilan, that you know for sure that 90% of administrative adjudication is untouched, because lots of people I talk to, including people in DOJ, are not at all sure exactly what jarcossy means, but think it could mean a whole lot more of that administrative adjudication is in fact touched. And even your point about, essentially cease and desist loan, you can't participate in an industry, many would consider to be more equitable and not the common law. So in fact, I think it could be much more extensive. The point is, we don't know. And then, last thing, I'm hoping we're gonna get some questions on major question, but it's major question that I think also holds a really serious problem potential for your hysteria.
Okay, I'm going to withdraw my word hysterics. I don't like it that much, but my angst. How's that?
I like angst.
To questions, major questions especially, would be welcome. Somebody's walking around with a mic, and so can we have hands? I have a hand from my colleague in the front row. If you guys could just say your name and who you are, that would be great, so we know where the question is coming from, and then a quick question. Thank you.
Thanks to all of you. Nick Stephanopoulos, professor here at the law school. In my field of election law, a lot of scholarly energy goes into legislative advocacy, thinking through how Congress or state legislatures could override court doctrines, court decisions that the people think are imprudent. And so I'm wondering why that doesn't seem to be as much of a focus in the administrative law context. I haven't heard about a Fix the APA Act that administrative law scholars are all rallying behind. It seems to me that a Fix the APA Act could override most or all of the recent decisions that you were talking about, whether it's restoring Chevron deference, annulling the major questions doctrine, changing statutes of limitations for different cases. So why isn't this like the first item on the agenda for a future
This is great.
Congress?
Why can't we amend the 1946 Administrative Procedure Act, Jillian?
Well, we can, except for the fact that we would run into some landmines in Congress is part of the issue. There actually is a proposal to address corner posts by legislation, which may very well happen. There has been the Separation of Powers Restoration Act, which was to overturn Chevron, that was pending for a long time in Congress. I do think there's a lot you could try to do with statute, and that would, of course, then tee up the constitutional question, which has been avoided. But certainly it's possible. It's just I don't think it's going to get enacted. And we just have an interesting tradition in administrative law that a lot of our doctrines or rules are determined by common law development over time, unless you have a statute, but then it gets developed, like the major question doctrine, which is your prime example of common law development.
I'm not going to have you both answer every question. I'll just direct the right ones and hope I'll get the right person when they're asked. So another question.
I'll say what I want anyway. Right?
You can just chat. You can just chat openly between questions. Nothing?
Well, while someone's thinking, can I respond?
Oh, Andy Mergen.
We haven't talked about Ohio v. EPA.
Here we come.
And I want to get your reaction in terms of what the court, of the 4 public law cases, admin law cases, 3 were decided 6-3. Ohio v. EPA, Justice Barrett joins the dissent. There are those of us who fear that they're changing the hard look test there, and that would impact sort of the footnotes 5 and 6 in Loper Bright, right? It seems like the government's getting squeezed at both ends, right? You've lost Chevron deference, and at least agencies like EPA are going to be under a harder look, and I wonder what your reaction to that is.
I'll direct that one to Ilan.
So in answer to the prior question, let me say 10 seconds on the prior question, which is whether you can reenact Chevron deference as a constitutional matter. I think depends on whether we're dealing with public rights cases versus private rights cases. And so on the public rights point, by the way, not all private rights cases require juries. So I think like banning someone from an industry, that's equitable relief, but it might still have to be in Article 3. And there is a solution to those kinds of questions, which is why not make administrative law judges file reports and recommendations, just like bankruptcy judges do in stern claims, right, where it's supposed to be heard by an Article 3 court. I think that would be efficient, that's a process, and so someone should draft that legislation. I have a draft, actually, if anyone is interested. On the Ohio v. EPA, let me just say, I did not detect that hard look is threatened. So I'm gonna have to go back and look carefully at that. I do think Ohio v. EPA, right, which is this emergency posture, which was decided in this emergency posture, does reflect, again, a zeal among the justices for the so-called shadow docket or what have you. And is, in an ideal world, would they be doing these things on an emergency docket like this? Probably not. On the other hand, what they have in mind, I think, is West Virginia v. EPA, where they said, look, the Clean Power Plan is unlawful, and it took us 6-7 years for it to arrive at this court, and everyone already has complied with that plan. And we're not going to let
Michigan, I think.
Oh,
I think Clean Power Plan was never implemented. But you're right about.
Well, it was not, right, but it had been complied with by almost all the industry participants at that point. From what?
It was stayed.
No, it was stayed in
From the very
2015. The industry just did it because the industry was moving that way anyway. But your point is Michigan. Your point is they were upset about a toxics law that everybody complied with and they thought they had to stay it. Other questions? Okay, I think we are we 1:20 wrap up? I want to just, before everybody leaves the room, emphasize something the dean said at the outset, which is the importance of a forum like this, where people debate weighty issues of the day that matter to our community and to our society and, in fact, our world, where there are very strong feelings, indeed some passions on both sides of the issue, but it can be discussed in a constructive, interesting, indeed friendly, and even funny sometimes way. And this is a model for all of us at HLS and more widely, and I couldn't be more delighted to get to participate in a forum like this. And thank you to the Rappaport Foundation for doing this, and to Jerry Rappaport, who established it with his wife, and to our wonderful guests, Jillian Metzger and Ilan Werman, for schlepping here and spending their time and energy with us to demonstrate such a wonderful model of constructive debate. Thank you very much, and thank you all for coming.
Thank you, Jerry. That was a lot of fun.